The doctrine of state immunity. State may not be sued without its consent. The rationale of the doctrine of state immunity is that there can be no legal right against the authority which makes the law on which the right depends. Likewise, there is immunity enjoyed by other states consonant with the public international law principle, par imparem non habet imperium. Again, par imparem non habet imperium. The head of state, who is deemed the personification of the state, is inviolable and thus enjoys immunity from suit. The state's diplomatic agents, including consuls, to a certain extent, are also exempt from the jurisdiction of local courts and administrative tribunals. The United Nations, as well as its organs and specialized agencies, are likewise beyond the jurisdiction of local courts. Tests to determine if suit is against the state. If the enforcement of the decision rendered against the public officer or agency impleaded will require an affirmative act from the state, then it is a suit against the state. Likewise, a suit is against the state regardless of who is named as defendant if it produces adverse consequences on the public treasury, whether in the disbursement of funds or loss of property, the public official proceeded against not being liable in his personal capacity. Consent to be sued may be given expressly or impliedly. Expressly, when there is a law expressly granting authority to sue the state or any of its agencies. Impliedly, when the state enters into a private contract, unless the contract is only incidental to the performance of a government function, or when the state enters into an operation that is essentially business operation, unless the business operation is only incidental to the performance of a governmental function, as for instance, a rastra service, or when the state sues a private party, unless the suit is entered into only to resist a claim. What is the scope of the consent to be sued? The court held that even when the government has been adjudged liable in a suit to which it has consented, it does not necessarily follow that the judgment can be enforced by execution against its funds. Consent to be sued does not include consent to the execution of judgment against it. The power of the courts ends when the judgment is rendered, since government funds and properties may not be seized under writs of execution or garnishment to satisfy such judgments based on obvious considerations of public policy. Disbursements of public funds must be covered by the corresponding appropriation as required by law. Now, as to diplomatic immunity, it is a recognized principle of international law and under our system of separation of powers that diplomatic immunity is essentially a political question and courts should refuse to look beyond a determination by the executive branch of the government. And where the plea of diplomatic immunity is recognized and affirmed by the executive branch of the government, it is then the duty of the courts to accept the claim of immunity upon appropriate suggestion by the principal law officer of the government, such as the Solicitor General or other officer acting under his direction.